Well, welcome everybody. Thank you so much for being with us on this beautiful Wednesday morning. My name is Jonathan Quatella, and I'm the Church Ambassador Network Director for Delaware Strong Families. And with me, I have today.
India with Delaware Family Policy Council. We're so excited to be with you once again. We have another committee hearing this morning that we're going to be listening into. This bill is House Bill 46. This is the bill to require parental consent for abortion. It's going to be an interesting hearing. I am excited to see what is going to happen this morning.
Absolutely.
Uh, I don't know what has the temperature been at Legislative Hall this week, John? How have things been going?
I think it was a really good week. I was at Legislative Hall yesterday, and I had 5 pastors with me yesterday. I think something that it was great. We met with some obviously new pastors that came, and I think that's a big thing that is happening. We're getting a lot new pastors coming to Legislative Hall that they've been there. Either they haven't been there for a really long time, or a lot of them is the first time they step into Legislative Hall. And yesterday we have the opportunity to meet with a new elected official we never met before. Is Representative Rose Levin, that comes from the Wilmington area, and I had Pastor Sam and Pastor Jonathan from Concord Baptist Church in Wilmington. So we were able to meet with their elected officials, so which is really, really cool.
That's awesome. It's so encouraging always to hear all that's been happening with the Ambassador Network and
Mm-hmm.
how you have all these new pastors coming and you're able to meet with legislators you haven't been able to meet with in previous years. And so it's neat to see how it grows every year.
Well, Rose Levin is a new elected official too, so that's the double
Right.
whamp there, and she was great. I mean, it was just being able just to meet and what Church Ambassador Network was about. Last week, we met with Pastor Jeff Pinder from Faith Baptist in Wilmington as well, meeting with his elected official with the new representative, Representative Burns, for the first time. So it's just all this great stuff happening. Praise the Lord.
That's awesome. Very exciting. Yes, absolutely. Praise the Lord.
So I'm
Very
looking
good.
at the committee for today, and you want to talk a little bit while I set this up, what we're looking at today.
Yes, so we have, as I said, the bill to require parental consent for abortion. This bill was actually scheduled to be heard in committee last week. And if you guys were with us last week for our live stream, last week was a packed week. We had a lot going on. So thankfully, right at the last minute, this bill was rescheduled for today. But what this bill does is it requires minors under the age of 16, if they go for an abortion, to have parental consent.
Mm.
Right now in Delaware, parental notification is the only thing that's required, no parental consent. So this bill is basically correcting a major parental rights infringement. And so it's something that's long overdue. I mean, we have parental consent for things much less life-altering than abortion. We have parental consent for even body modifications. I mean, you name it, and it requires parental consent. But for abortion, which we know is such a life-altering, serious decision, there's
Mm.
no parental consent. And so it seems like a common sense thing, but it'll be interesting to see the debate that happens, to see what the arguments are, and it'll tell us a lot about what our legislature feels about parental rights in general. So I think what we'll do is we'll listen in, and then
Yeah, I think
any
they're
we
talking
have
about it
will.
right now. So
Okay, let's tune right in and
The
see what
aisle
is
for
happening.
coming on board with this bill as well. It is a code change to put 2 additional members onto the Suicide Prevention Coalition.
this is the
And
suicide
those 2 members
prevention.
include one representative who has experienced suicide ideation or survived a suicide attempt, and also a representative who has lost a loved one to suicide. These 2 additions will help the other elected officials who are on the coalition understand the ground level, real time challenges of the individuals who are going through these exact situations of what this coalition is challenged to identify and hopefully move us forward with in the state of Delaware. I'm open to questions, but if not, I'll take a roll call.
Thank you, Mr. Chair. Representative Shoup, thanks for bringing this forward. Last week, I think it was last week, had the bill for the Office of Suicide Prevention. If that's enacted into law, how would this integrate with that?
So this I believe is separate. It's a coalition that's seen by the state of Delaware. I would think that if that is into the, if the office isn't put into law, they would have to define whether that comes under them or not.
Thank you. My only point last week was we have a lot of these different coalitions and different groups, and so if we're going to have an office, how does that integrate so we are condensing that and saving state resources while also having a bigger impact? So thank you.
So just real quick, I'll interject here. The bill that's happening right now has the same sponsor as the parental consent bill, Representative Shoup. So this is a coalition for suicide prevention that they're talking about, a relatively small procedural change, it looks like. So we're not thinking that it's going to last for very long, the discussion. So we're thinking they'll move right into the parental consent bill right after this.
Yeah, I don't know what the schedule is.
It looks like it's only these two bills this morning.
Oh, okay. So there's both under him. I don't know. I just got confused.
Yes. Sometimes it's a packed schedule. Sometimes there's 4 or 5 bills. So thankfully it's only 2. And again, this one doesn't seem to be generating too much discussion. So we should be hearing the parental consent one shortly. But let's see.
They're doing the public comments right now. I guess nobody's on the floor to speak on this one. They're waiting for the public comment when it comes to the Zoom.
Okay.
So,
if you look very carefully, you can see Nandi sitting in the back.
Oh, yeah, she is right there.
Testify for the parental consent bill. So she's on the floor and she says that there are some at least one powerful expert witness who's planning to testify. So I'm looking forward to hearing from her.
I'm just trying to see who's around. I don't see that many people.
Yes, it's not very packed today. Doesn't look like it. I mean, we don't know what the balcony looks like, but there's not very many on the floor.
Yeah.
Representative Michael Smith.
They voted
Okay,
on
so
HB.
the roll call now.
Yeah.
All right, here we go.
For consideration. We will now move to agenda item 2, which is House Substitute 1 for House Bill 46, an act to amend Title 24 of the Delaware Code relating to parental consent for minors seeking an abortion, sponsored by Representative Shoup. The floor is yours, sir.
Thank you, Chairman Triquocha and members of the committee, and I also thank you to the members of public that are here today in the chambers, but also listening online. HB 46 was brought to me by residents of my district and also residents across the state that are troubled, but also confused by the current laws that are surrounding abortions performed on minors. A few points in Delaware Code. A minor in most of the places in Delaware law is considered under 18. In this specific part of the code, this section, a minor is under 16. So today when we're discussing this, it'll be, we're talking about children that are 12, 13, 14, and 15 years old. I also, the fundamental purpose of this bill is to ensure that a major life decision, such as an abortion, is made within the family unit with the guidance and the support of parents or legal guardians, rather than solely between a minor and an organization that performs the procedure. A decision of this magnitude carries both immediate and long-term consequences, and it's critical that a child receives counsel from those who are legally and morally responsible for their well-being. Parental involvement ensures that all options and potential outcomes, including emotional, physical, and psychological impacts, are carefully considered. Abortion, like any medical procedure, comes with risks such as infection, bleeding, and emotional trauma. If complications arise, a parent should be aware to help secure timely medical care and emotional support. Additionally, a trusted adult's guidance helps protect minors from external pressures or coercion, ensuring that they are not forced into a decision without understanding all sides. Parents play a critical role in helping their children navigate difficult decisions, and their involvement in such a significant matter should not be overlooked. Ultimately, parents are legally and ethically responsible for their children's well-being, their health, and major life choices. This bill reaffirms the importance of family support in a decision that could have lasting effects on the young person's life. I also want to be clear that in cases of abuse, neglect, and in medical emergencies, Delaware law already addresses these situations under this code and has protections for these children. And HB 46 does not eliminate or change any of these protections. Chairman Chikwocha, if it is okay with you, I'd like to introduce my witness. She should be online. Her name is Danielle Pimentel, Esquire. She earned her law degree from Regent University School of Law, and she's an expert in the law relating to federal and states' reproduction rights. Danielle Pimentel.
I apologize. Thank you so much. Good morning. My name is Danielle Pimentel, Policy Counsel at Americans United for Life, which is a national law and policy nonprofit that specializes in early life issues. Thank you so much for having me today and for the opportunity to provide testimony in support of HB 46. I want to start by sharing the story of Nicole, who had an abortion at 15. Nicole published her story on a website, Silent No More, which is a platform where women can share their abortion experiences. And Nicole wrote, quote, "I was 15, afraid, ashamed, and I felt like I had no choice. The abortion caused me emotional, physical, and spiritual harm that I was never told could or would result. I was never given a pregnancy test, told about the procedure, or told the real truth about abortion. No one was there to hold my hand. I was distant and empty and contemplated suicide. We never told our parents. I could not forgive myself, and I was never able to conceive a child after my abortion, and I am now 50 years old. The pain is still there. Abortion scarred me," end quote. I know that this committee joins me in wanting to protect pregnant adolescents from suffering the kind of trauma Nicole experienced when she was just 15 years old. But unfortunately, many young girls share Nicole's experience, especially in states that do not have strong parental involvement laws. And that is exactly why HB 46 is necessary. The bill aims to strengthen the state's current parental involvement laws to ensure adequate protection for pregnant adolescents seeking abortion. And the bill not only recognizes the fundamental rights of parents to make decisions for and with their children, healthcare decisions, but it also protects the physical and emotional well-being of children who, facing an unplanned pregnancy, need the love and guidance of the people who care about them most. And parental consent and notice laws are indeed among the most accepted regulations of abortion and are constitutionally permissible, which is why we see that 35 states have enforceable parental involvement laws. And since the Supreme Court has overturned Roe v. Wade and in Dobbs and lifted the undue burden standard, states are now free to draft parental consent laws to fully vindicate parental rights and safeguard the health and informed consent of minors. And Dobbs held specifically that states can indeed regulate abortion if they are doing so in furtherance of a legitimate interest, one of which being preserving maternal health and safety. And HB 46 meets these requirements laid out by the Supreme Court in Dobbs because it does further the state's legitimate interest in protecting pregnant adolescents from the inherent physical and psychological risks of abortion. And you heard Representative Shute lay out some of these. Pregnant adolescent girls, we know, are a particularly vulnerable population given their continuing physical development. So there are unique challenges that they face when seeking an abortion, which is why it is imperative for Delaware to strengthen its safeguards. Adolescents do not have fully developed decision-making capabilities, and this is true for minors facing an unplanned pregnancy, which is why the medical, emotional, and psychological consequences of an abortion can be severe. And studies do show this. They show that abortion has a negative impact on women's mental health, including that it's consistently associated with elevated rates of mental illness and increased correlation to substance abuse and suicidal ideation. So given the negative impact abortion can have on a minor's mental well-being, strengthening parental consent laws is critical. And many adolescents may have high-risk pregnancies, which is compounded by the fact that they often delay care. And they can be doing this because lack of knowledge of the importance of prenatal care. They could be victims of violence or domestic abuse. Maybe they may be trying to hide the pregnancy or contemplating an abortion, etc. But these delays obviously result in adverse outcomes often, and may lead them even to seeking an abortion farther along in pregnancy, which subjects them to increased risks of health complications. And so this is why parental guidance is so instrumental for a adolescent patient's informed consent, because their parents can help their daughter select a competent healthcare provider that prioritizes their health. They can help provide additional medical information and history to the abortion provider. They can ensure that she's not being coerced into having an abortion by a boyfriend or any other person, and ensure that their daughter understands fully the risks of the procedure and give her the advice that she may need. They also can monitor for post-abortive complications, which can be life-threatening. And so parental consent laws are important more now than ever, now that the Supreme Court has overturned Roe. And there's a long line of case law dating back to the 1920s when the Supreme Court in fact declared that the U.S. Constitution protects the fundamental rights of parents over the care and upbringing of their minors. So HB 46 ensures this kind of parental involvement by requiring a parent or legal guardian's written consent, engaging them directly in the informed consent process, and directly vindicating their constitutional rights to know about and participate in their minor's major medical decisions, leading to overall better outcomes for that minor. And for these reasons, I respectfully ask that you vote in support of HB 46, and I'm happy to answer any questions. Thank you so much.
Representative Ross Levin.
So I have a question for the witness.
Yes.
What is your medical background? Specifically, how are you qualified to speak to the impact of this bill on the health of adolescents, both physically and mentally?
Thank you for that question, Mr. Chair and the Representative. So I am an attorney, and we work with medical professionals in our organization. So any statistics that I'm listing are from other medical professionals, studies, things like that. We're now are leading medical experts. So anything I'm saying is based off of the opinions of medical experts, and I'm speaking from my own legal background as to the benefits of this bill.
But you don't have any actual medical expertise, is that correct?
No, I'm an attorney.
Okay. Just the reason why I think it's important for the committee to know that national medical groups like the American Academy of Pediatrics, the American Medical Association, and the American College of Obstetrics and Gynecologists oppose mandatory parental involvement laws because they increase harm to young people by delaying access to critical care and threatening the privacy and safety of vulnerable young people. So I think it's important for the committee to know. Thank you. May
I respond to that?
Shoot.
And I understand exactly what you're saying, but let's make clear that this bill does not delay access to critical care in any way. There are protections in Delaware law, and it does not touch those protections. So there's no delay in care, in critical care.
Sorry. Sorry. Thank you. So that has not been the case in other states that have had laws like this. So
that's why we specifically left all of the protections for medical emergency, abuse, and neglect exactly the same as it is in Delaware law right now.
So the understanding is that vulnerable adolescents would be able to navigate those.
This is currently what's happening in Delaware law right now, is that any case of abuse, neglect, or medical emergency is handled by the organization that would be providing the abortion and the minor, and they walk her through that procedure. That is happening now in Delaware through Delaware law, and that stays exactly the same if HB 46 passes.
Representative K. Smith.
I want to thank the witness for giving her testimony, but I have a question. You made mention of all of the side effects or the medical things that may happen as a result of abortion. So would that change whether we have consent or whether we have notification? Does that change?
Well, I mean, there are inherent risks to abortion. However, having a parent involved can help ensure that if their daughter is, suffering any kind of post-abortive complications, that she's going to receive the best possible care and treatment as soon as possible. Also, I think the assumption is that abortion is always going to be the best option for the minor, and that may not actually be the case. And so having the parents involved who know her medical history, who know her mental well-being, etc., can work alongside her and her doctor to figure out what's the best course of action when she's facing unplanned pregnancy, which they could agree could be an abortion, or they could agree it could be other options like carrying the pregnancy to term. And so I think there's a presumption that there's some kind of conflict between the parents and the daughter, and that might not always be the case. There may actually be many instances where the parents and the minor can agree as to what's best, but having the parents involved is critical to ensure that no matter what course of action, that daughter is going to receive the best care from the best medical professionals, no matter what that option is or what they decide. And there are still risks to abortion, as there are risks to many other medical procedures. However, having the parents involved ensure that if there are any complications, that minor is going to receive prompt and appropriate care.
Thank you for that. So with the risks that are involved, are we saying that the risk is greater if they have notice and not greater if they have consent?
No, let me clarify. My position is that if a minor is going through the abortion process without the parents involved, there's greater risks of harm to her. So if the parents are involved and through the informed consent process, then that can help lower the risks to her, whether that's through notification or parental consent. But if she's going through this process and there's no sort of parental involvement, well, again, if she's going through chemical abortion or surgical abortion, et cetera, and experiences complications, then again, she may not have the support that she needs to get the care and time to help remedy whatever complication that she's experiencing.
Representative Shoup.
Yes, if I may, I wanted to add to that as well. I think that it would help just the general public and maybe some individuals looking at this bill in this chamber as well to understand the notification process right now. The notification process is meant to notify parents, but that is not the case. So the notification process through the state of Delaware is that a certified letter has to be sent to the address that the minor gives. Now, a signature has to be placed on that certified letter. Now, when you sign a certified letter, all that means is that the letter has been delivered to that address. That does not mean that the parents have been notified or the parents acknowledge that the abortion is going to happen. That's just literally a signature saying that that letter went to that address. So it says notification, but the residents that reached out to me in my district and across the state are very confused to, if you're going to notify the parents of this 12, 13, 14, or 15-year-old, it doesn't make sense that that notification in law doesn't actually denote that that parent has to sign off on that notification to acknowledge that that's happening.
Representative Burns.
Hello, this is a question for the witness. On line 59, it says in cases where parental consent is not possible or is deemed inappropriate due to relevant proof of abuse or neglect. Under Delaware law, what is that proof? Is that adjudicated? Does this have to have been, it doesn't say suspicion or reasonable suspicion or anything. It says in the bill proof of abuse or neglect. So since you're the legal expert, I would ask you to tell me what that wording means in terms of proof under Delaware law and how that would impact what would need to be done for a minor to be able to take a different route to access the health care they're seeking.
I am not a Delaware attorney, so I can't necessarily speak to what that would be, how that would be defined in Delaware, but I can say, at least for the plain meaning of the language of the bill, it would be any kind of, because the bill goes on to state that the court can grant a waiver if there's clear and convincing evidence that there's parental consent is not in the best interest of the child because of abuse or neglect. And so I take it that for a normal process in a courtroom, that could be the minor's own testimony of any kind of neglect or abuse that she's experiencing, as well as maybe other witnesses. But I can't speak specific as to how the Delaware code defines that, just because I'm not a Delaware attorney. But in general, in the legal process, you know, most of that process would look like, or evidence would look like, probably the testimony of the minor themselves. And again, any other testimony from other witnesses that can support her testimony that she is experiencing abuse or neglect. And that could be, maybe she has, you know, photos or whatever that might be to support that.
Representative Burns.
But it would have to be clear and convincing evidence, which is what the bill lays out as the standard.
I realize you're not a Delaware attorney, so maybe you can't answer this. Do you know what the timeline is for a minor to go through that kind of process in reality, in actual practice in the state of Delaware?
To clarify, Representative, you mean the judicial bypass procedure? Is that what you're asking?
Yes.
Yes, so they can immediately, whenever they'd like to, if they're seeking an abortion, file with the court that they're wanting to seek a waiver of the parental consent requirement, and the court is required to rule on that within 5 days of receiving it. And if they don't rule on it within 5 days, and it's deemed to have been, the parental consent requirement is deemed to have been waived. So this is a very quick process to ensure that whatever the court decides, that decision is communicated to the minor and she can move forward with whatever that decision may be.
Representative Shute.
I just want to thank Representative Burns for bringing those questions. I think most Delawareans probably don't know that procedure, but I just want to remind everyone listening that that is current Delaware law and will not be changed through this bill.
Representative Snyder Hall.
I guess I'm a little bit confused. The sponsor of the bill said in the introductory comments that it's important for the decision to be made within the family unit, and that the child would need to, should be getting counseling from the parents. But this isn't a question of notification, right? This is a consent bill. And so I guess the sponsor cleared it up a little bit by talking about the letter and all this. But my question for the witness is there any, do you have any evidence of what percentage of pregnant teenagers have their parents involved in their decision-making process? Because it seems to me that, you know, with parental notification, I mean, most children would be talking to their parents about, unless they have a good reason not to, talking to their parents about this monumental decision. I mean, the story that, the anecdote that was told at the beginning by the witness was troubling, but I also think about, you know, my friend who's in her 70s and is still haunted by being forced to bear a child and having that child put up for adoption. And it's still very raw for her, even though she's in her 70s. So, you know, there's one thing about having your parents being able to counsel and advise, and, you know, they have a front seat, you know, opportunity to pressure or try to convince their daughter to, you know, have the baby or whatever. But ultimately, it's her life, right? And so my question is, what are the statistics in terms of how many pregnant teenagers actually do consult with their parents and how many don't?
Thank you so much, Representative, for the question. And I don't have an answer to that. I'm not aware of any statistics. However, I will say that it is common practice in the medical field in most areas when a minor is considering a major medical decision to have parental consent, to involve the parents in that major medical decision. That is best practice, common practice, and is deemed by leading medical experts as being appropriate because minors have still developed decision-making capabilities. And again, the presumption is that, and this is true in most cases, that parents have their children's best interest in mind, and so they're able to speak to things like medical histories that the patient themselves may not be aware of. And that's why, as I mentioned earlier, the majority of states have parental involvement laws, whether that's parental consent or parental notification when it comes to abortion, because, again, of that need to ensure that parents are involved in that informed consent process so that whatever decision is made, it's made in the best interest of that child. So I don't have specific statistics, unfortunately, to provide to you, though, in terms of day-to-day with my teens and how they're involved with their parents. But again, the purpose of this bill, as Representative Shoup said, was to ensure that minors are protected in the informed consent process, and some of the best people to speak to a lot of those things that are involved in the informed consent process are the parents, presumably, because again, they know their daughter's medical histories, they know their daughter's background, they know what she may be allergic to in terms of medical medicines, et cetera, things like that the minor herself may not be able to provide. And they also, part of the informed consent process is counseling as well, right? It's walking their daughter through what options are available to her and working with their daughter to figure out what's the best option for her.
Representative Snyder Hall.
Right, but Delaware already has parental notification, right? So this is not necessary.
Thank you. Representative Halowski.
Thank you, Mr. Chairman. I wanted to kind of talk a little bit about coercion of children and how maybe, and I want to ask the witness how strengthening parental consent laws would have an impact on a child being potentially coerced into having a procedure.
Thank you, Representative. There are high rates of intimate partner violence and reproductive control among women seeking abortions. And that's why the American College of Obstetricians and Gynecologists has actually noted that among women seeking abortions, the prevalence of intimate partner violence is nearly 3 times higher than women continuing a pregnancy. So there's a lot of risk, especially for minor girls, of abuse and coercion from an intimate partner, so a boyfriend, whoever it might be, to obtain an abortion, which against their own wishes. And so, and again, we looked at studies to show this as well. A recent 2023 study found that women reported, 60% of women reported feeling high levels of pressure to abort from one or more sources, which includes from an intimate partner. So HB 46 helps to protect against that by ensuring that her parents are directly involved in that informed consent process so that they can safeguard and ensure that the pregnant minor, whatever decision that she's making, she's doing so voluntarily. And so if she's seeking an abortion, they can ensure that that's a decision that she's wanting to do voluntarily, not because she's feeling coerced or pressured from friends, from her boyfriend, whatever that might be. And it's not being influenced by those bad actors, but is seeking that voluntarily. So having the parents involved helps safeguard against that type of coercive abuse, which unfortunately we do see in cases of abortions at times.
Representative Halowski.
Yes, I'd just like to make a comment. First of all, thank you for your answer. That was helpful. But as you were saying your answer, I was struck by, what actually happens during pregnancy, the physical changes, the chemical changes inside the body, the emotional changes because of the chemical changes inside the body. And and this is a statistic that is really irrefutable, that this generation of children that are now coming up have more psychiatric and emotional problems than any other generation of children in our history. And it's troubling to think that we would campaign maybe to exclude the parents from this, as the parents are so integral in their daughter's development and also emotional support. And then you think about potential complications after an abortion. And again, the chemical changes inside the body and the amount of social pressure, personal pressure, self-induced, that may be occurring in this child. And I would hope that there would be a path forward to make sure that the parents are involved, and so that they could support their child, and so that they don't have the situation where the person who was that she spoke about initially in her first comments, and also other people who have had similar situations can be certainly taken care of in a way that's proper, that doesn't leave them emotionally scarred for their life. Thank you.
Thank you, sir. Representative Heffernan.
Thank you. This is a question for the sponsor. Are you aware that the American Academy of Pediatrics and the American Medical Association oppose mandatory parental involvement laws, and the reasons they give are that it can increase harm and delay critical care?
I think we already responded to that with Representative Ross Levin, but I'll respond to it again, that this specific bill does not delay access to critical care. It keeps the protections in place that are already under Delaware law about access to or protections for children that have been abused, neglected, or in emergency situations.
The part I asked if you were aware that American Academy of Pediatrics
Yes.
and American Medical Association are opposed to these type of bills.
I said yes, and this is not this type of bill because of the protections are still in place.
Are you finished, Representative Heffernan? Okay. Representative Ross Levin.
I just want to point out something that the witness said. The witness said it was a best practice, which, not to harp on this point, but if it was a best practice, all of these medical associations would be supporting these types of bills, and they do not. So I think that I wanted to correct that for the record. I also wanted to say that Delaware law does not require parental consent for prenatal care. So I guess this is for the sponsor. What is your justification for singling out abortion care but not prenatal care?
That's not part of the bill, so I don't have had time to look at that. You can bring that forward if you'd like.
I just think that that's inconsistent, and we need to trust women. And I think, I think ideally, yes, people would involve their parents. What we know is that people who can involve their parents do involve their parents, and if they don't, they have a good reason to. So for that reason, I'm not supporting this bill.
If I can make a response to that, we are talking about children, ages 12, 13, 14, and 15 years old. We're also talking about many children who are isolated in this discussion with the organization that's providing the abortion. That's what's happening now. Instead of having, the organizations that are providing it are not their primary doctor. They don't know their family history. This bill is allowing for the people that, under Delaware law, legally have to care for them. Under Delaware law, the parental rights and responsibilities is parents and legal guardians are responsible for the care, custody, and control of their minor children, and they have the authority to make the decisions regarding a minor's education, health care, and general welfare. The parents are responsible for children.
Representative Rowe, I'm sorry, I'm coming to get to you. Representative K-Smith.
So I just want to unravel some things in my head. So I understand that we're trying to amend it from just being notified to being consented, to getting consent. So as I'm reading through, starting I guess on line 34, they'll receive consent, but the consent must be obtained at least 24 hours before the abortion is performed. So we're still like in this 24-hour period. So if the parent says no to the consent, do we know what then happens? I don't know if that's a witness question. Like what happens?
I can answer that.
Okay.
So if the parent says no to the consent and the child feels, again, that they are being abused or neglected or anything that fits under the current law in Delaware, then they have the ability to go through the current channels under Delaware law to ask for an abortion.
Which is like that, getting the letter. So we want a 12-year-old, 12, 13, 14-year-old to get a notarized piece of paper, which would need to be held by an adult.
This is already current law. This is what's happening right now, and that's the reason we did not change that.
You finished? Representative Johnson?
Thank you, Mr. Chair. I have comments. I don't require anything of the subject matter expert. I'm really baffled as to why we are here, considering we know that Delaware law already requires medical providers to notify a parent, guardian, grandparent, or a licensed mental health professional before providing abortion care to a minor. So let that stick. The next thing I'm going to say is, if this young person is not including their parents or guardians in this conversation, please know that there is a reason for that. And perhaps we ought to, sorry, not sorry, look at the relationship that that young person has with their parents. Perhaps it is not a relationship of safety and security. That's one thing. I have been that young girl who was not safe in her home at an early age. Now, did I need an abortion or seek an abortion? Not at all. But if I had to, you can best believe I was not in a family environment where I could have those type of conversations and get their consent. I'm going to take deep cleansing breaths here. We already have a law that exists, and it works. For those young people who include their family members in these conversations with them, God bless them, because that means they have a good family structure. For those young people who don't have that, God bless them. We ought not do any additional harm to young people. Period. No one takes it lightly, regardless of your age, the thought that you have to terminate a pregnancy. And for us to provide additional stress on young people when we don't know their background, how dare us? There are so many reasons why I cannot support this legislation, and I will not. But I won't take any more of your time. Unless, of course, I hear something that sends me over the edge, and sorry, Mr. Chair, my hand will go up again. But no. Just no.
Representative Shute.
Yes, if I may respond to some of that. There is a notification process in the law of Delaware. It does not ensure that the notification is actually to the parents. That is not part of the law. All it does is certify that that piece of paper was delivered to the address. That is not parental notification. Number two, I don't think that we can assume the relationship that a family has with a minor based on whether they tell their parents about a life-changing event that's going on in their life. These are children, and many times they don't know what to say. They don't know what to do. They're scared. There can be a myriad of situations where there are great relationships in the home, or maybe that child feels scared because there's other things going on in the home. There may be other sicknesses, or maybe other divorce. They don't want to put their burden on their family. I can't tell. I'm not part of that family. There are so many different levels of things going on in that child's mind that I can't say that's a good relationship with the parents or a bad relationship with the parents, because a minor who doesn't have the capacity, mental capacity to make life decisions like that, and that's why we're their parents, to guide them through decisions like that. So I caution against saying that it's a bad parenting situation, and I'm not saying that the representative did, but I've heard that argument in other places. And then the other portion is, again, if that child feels that they cannot go to their parents of fear of repercussions, there is protections in Delaware law to help that child, and that this bill upholds those protections. It does not alter them. It does not eliminate them. So I just wanted to respond. I understand the concerns from my colleague. I love her to death. She knows that. We know that we disagree, but we still got love between us. I just wanted to respond my feelings on this side.
Representative Johnson.
Yeah, thank you. So, yes, Representative Shute, you know I adore you. And we can share with the whole world, he and I, we share gospel songs together. We'll send them back and forth. I'll send him some good stuff. He sent me some good stuff. And yeah, we agree and disagree on a lot of things. What I have decided, thank you, Mr. Chair, is that I won't belabor the point, honestly. I've said what I needed to say, and it's not going to be sweet, but I appreciate that you've given me the opportunity to speak again.
Representative Smith.
Thank you, Mr. Chair. Just to take the temperature down a little bit, Representative Johnson was Delaware's Woman of the Year. Just would like that to be on record for the audience. Anyway, look, the temperature automatically goes up, and so does the passion on this topic, and with everybody, right? It can get everybody. When you say the word abortion, automatically red flags go up for somebody, and their preconceived notions or everything is already there. You can't take that away from people because the passion's there. I respect Representative Shute for bringing this forward, because really what this is not an abortion bill, but a legal bill. It's closing a loophole. It's a loophole bill. And so I just want to frame that slightly differently. Just because the words abortion is in it and it's in the Health Committee, we don't have to necessarily look at it that way when it is closing a loophole. As a father, I know with some of the things going on in our schools right now, I'd be pretty pissed off if my son or daughter were not to come to me with what's going on with some of these messaging apps and things like that. Also, when it comes to every other procedure, I don't know any child that isn't coming to their parent with a procedure, because it's generally going to be on their insurance or on state insurance or some sort of insurance plan. I definitely understand what he's trying to do in terms of keeping the cohesiveness in the home. I also know, because of trauma from my childhood, that sometimes you can't trust adults, as we're seeing in the news today. But that's where those protections are already in place. And I don't want to belabor that point, but that is in place. And so I just wanted to make that point, that we don't have to look at this as an abortion bill when it really is closing a loophole. So I appreciate the dialogue today, though. It has been respectful and very passionate. I see some hands going up, so let's keep this rebuttal going.
Representative Burns.
Okay, I did want to point out that according to the American Medical Association Code of Medical Ethics on confidential care for sexually active minors, their ethical guidelines are that a minor should be able to consent to medical care and that the provider should not notify parents without the patient's consent. So already by requiring notification, we are more restrictive than the guidelines of the American Medical Association. I would also like to point out, my mother was sexually abused by her stepfather up until she ran away from home permanently at the age of 12. When she went to her mother for protection, her mother beat her for lying about her daddy. So this idea that parents are always going to be the right person to go to, and she wouldn't know. You must have a lot more faith in Child Protective Services than is appropriate. There are a lot of people and a lot of young people living in situations where they are unsafe because of their parents, where there is no evidence or proof. And I would point out that one of the big surprises that have come out of all the genetic testing that's going on is the incredible number of people who are, when they get tested, find out they were the products of incest. This is something that's real. There are a lot of reasons why a person who's pregnant may not want to have their parents notified even, as well as involved. I think that this actually makes it more difficult for people in the worst situations.
Representative Shute.
If I could respond, this seems to be an ongoing counter, and I understand why. But these protections for abuse, neglect, and medical emergencies are already in place for Delaware law, and this law does not change any of them. And I just want to make that clear again.
Thank you. Representative Snyder Hall.
I agree with the sponsor's comment that pregnancy is a life-changing event. It's a life-changing event for the person who gets pregnant. And ultimately, she has to decide. A lot of, children, the use of the word children, I think, is a little bit distorting because it's, have reached the age of reason as a teenager. Teenagers are held responsible for a lot of behavior, criminal behavior and so forth. But when it comes down to it, if you get pregnant, you grow up real fast. It's your decision. You're a moral person, and you have to live with the decision you make for the rest of your life, and it's not your parents' decision. Ideally, you will be in conversation with your parents and other trusted guardians to help you make a good decision. But bottom line, it comes down to the person whose life is being infected is the one who gets to decide, even if that person is younger than we might think is ideal.
Representative Jones-Giltner.
Representative Shoup, I'd like to thank you for bringing this legislation forward because it brings alignment in areas where Delaware code is incongruent in both the definition and treatment of a minor. You said earlier that this, and only in this area do we consider a minor to be under 16 instead of under 18. We are incongruent in our determination of what informed consent means for a 12 to 15-year-old, the protection of minors. And we flip-flop when we think about whether the parent or guardian should be part of educating, informing, guiding, versus when we should leave that child alone out there on an island to figure things out during what could be one of their most traumatic experiences of life, physically, mentally, and spiritually. We are quick in this room to protect the child from a bad parent relationship, but we are ignoring the child that is in a bad or bullying relationship, or maybe in a positive relationship with the father of the child, but I mean, the baby father, but says, oh no, you can't have this child, you have to have an abortion, and then he becomes the bullier or the coercion. And so we've blocked the parents from supporting that. In this building, we hear in different committees whether a minor can be held responsible for their actions. You can go to the education committee meeting and hear constantly that we can't hold somebody that's had bad behavior in a classroom, a minor, responsible for their behavior because, and I'll quote somebody, they don't know what they are doing. They have not developed mentally to be responsible. But yet you come into this chamber, this committee meeting, and suddenly we're thinking that a 12-year-old can be held responsible for the behavior. In Delaware currently, if that minor child needs to have a laparoscopy for ovarian cyst, I'll just give you an example, we have to have informed consent for the parents, or from the parents. We have defined what that informed consent looks like, and it looks differently for a patient that's going through a lap for ovarian cyst versus a minor that's going through it for abortion. So we're inconsistent constantly through Delaware law. I'm going to share an experience that I had. A lot of my friends here know that my husband died post-vasectomy at age 32 from bilateral pulmonary embolisms, clots that went to his lungs. After he died, we found out that he had a genetic marker for clotting. If my 12-year-old daughter had a procedure, she is at extreme high risk for dying from blood clots also. I would want to be there with her for any procedure related to her reproductive health or otherwise. And so when she went into Nemours at age 14 for a physician visit and they removed me from the room, that's when I first became aware of this whole area of the law. My daughter told the physician that she was very comfortable and had a close relationship with me and would like for me to be in the room, but they still kept me out of the room despite her request. So I'm of the mindset, even though I'm a clinician, that sometimes we go beyond in protecting that child who has a good relationship with her parents. And so I'm in all support of this. I think that we have to gain alignment in who we recognize as a minor and where we have parent involvement. We don't allow someone under 18 to get a tattoo. We don't allow them to buy cigarettes. And we request a parent permission when they go on a basic field trip. So thank you.
Representative K. Smith.
Thank you for sharing that. I do agree that we have some missteps in our law and some things that are just, they're not congruent, just as my colleague said. But the part that I am struggling with on this bill is the fact that we will interrupt some access for people. And that's where I'm struggling, that they will not be able to access what they need and when they need it, regardless of whether they're 12, 13, 14, 15. It's just the access for me.
Could you explain exactly where do you think the access would be prevented?
Because
So
if the parent does not consent, they will not be able to get the treatment that they need. There will be some hoops that they'll have to go through in order to get the treatment. Then the other part, and I don't know if it's appropriate to share it on this floor, but for me to share this on this floor, but you shared that our notification and how that notification is done, that's a hole in our system, right? Like there's something that needs to be done about that. Like why can't we clear that up? Is my question.
So with, I answered before, I'm not sure which representative asked this question, but without the consent, maybe it was you, without the consent, they can go through that process. That is the same process that is now. So if they wanted to not have the notification go out because they don't want their parents to know, it would be the same exact process now as it would be if they have the consent and their parents said no and they wanted to move forward. It would be the same process that's in the law now. I agree with you. There is a piece in the law that's not, and this happens all the time, right? That something, we write a law and it sounds great, but on the ground level, it's not doing what it needs to do. So this is in turn shutting that loophole, but really at the same time, it's also including the family to be there with the child when this decision is being made. What I hear from parents is that they are worried and troubled that a child is being, when they have to make this decision, is basically in isolation with the person or the organization that will be doing this procedure. And that's where all the information is coming from. That's where the decision-making process is coming from. And that's where they're getting all their information, where the decision is being made. And as a child, they're taking all this information in. And through Delaware law, there's no process for the family to be involved on the ground level, for them to hear what else is available, what is taking a global look at what this actually means.
Representative Ross-Levin.
This is a question for Representative Shoup. When you say you've talked to parents, are those parents that have actually experienced the notification system, or is this in theory?
Both. So both that have seen the notification come to the house, mm-hmm. and parents that looked at the law and said, this is not what we need. We need more parental involvement. I will say that I had not, and I don't know if this is relevant to you or not, but mm-hmm. I've not had a single man reach out to me and say this needs to be changed. This has all been women that have reached out to me throughout the state of Delaware that said this law needs to be changed for the state of Delaware so families can be involved with this process.
So how many people who have actually experienced the notification system directly that you've heard from?
I don't know if I could. I've had dozens of people reach out to me. I don't know if I could put a number on.
So the reason I ask is that pregnancy in Delaware under the age of 20 is quite low, and it's fallen dramatically over the years. And so I'm trying to figure out what problem we're trying to solve.
The problem we're trying to solve is that parents are not involved when a child is facing.
And we think forcing parent involvement is the way to go.
This is allowing parents to understand what's going on in their child's life.
Yeah, so I think, well, a couple things. One, I just think we just have to agree to disagree. I think we just have different strategies. I did want to respond to Representative Smith's comment that this was a loophole bill. This is definitely not a loophole bill. No one's fooled that this is a loophole bill. a loophole bill would not do harm to Delawareans. A loophole bill is something that we throw on a consent agenda. So I just want to make that very clear.
Thank you. Representative Postles.
Just wanted to make a comment here. This proposal is entirely consistent with Delaware law in that it recognizes minors are emotionally and intellectually underdeveloped. I think that's been pretty well established and agreed upon. And so that decisions that they make as a 12, 13, 14, even 15-year-old could really affect their life dramatically and is a risk to their welfare. Having the parent involved has the opportunity, admittedly, not the guarantee, but it has the opportunity to intercede on that. As was mentioned, minors can't buy or use alcohol or cigarettes. They can't get tattoos. They can't even go on a field trip without parental consent. And yet we're asking them to be involved in a very serious, life-changing, and in some cases, life-threatening, if things get sideways and medical things don't go well, there are unknown medical issues that are not brought to the attention of those providing the service. Why do we want, even if that's a small group of people that are involved, why do we want to put those kids at that level of risk by not having the parental consent involved? It boggles my mind that even for a small number of kids that this may affect, why we would say, they're not worth it, forget it. Thank you.
Thank you. Representative Snyder Hall.
I appreciated Representative Ross-Levin's question about what is the problem we're trying to solve here. And Representative Shoup, you said the problem is that parents are not involved. And I asked earlier the expert witness if there was any evidence that the parents are not involved. And she said she didn't have any, right? How do we know that parents aren't involved? Why wouldn't parents be involved? I can't imagine that in most cases parents would not be involved. You know, I mean, like you have anyway, so I'd like to know if there is any actual evidence that parents are not involved.
The Delaware law currently does not allow a process for parents to truly be involved.
But that doesn't prevent that doesn't tell you whether a girl who's pregnant is talking to her parents or not. It has nothing to do with Delaware law. It has to do with her turning to the people she trusts or somebody who can help her in a crisis, right? What the law says doesn't tell us anything about whether parents are involved.
Representative Burns.
Yes, I was just wondering if if you know how many of these parental notification letters go out every year, and of those, how many are signed for by someone who is not the parent?
I don't know those statistics, no.
Representative Mike Smith.
Thank you, Mr. Chair. To Representative Ross-Levin, you said it's not a loophole bill, but it's a bill that hurts Delawareans. Can you show me which line specifically states that in the bill? Since you know with absolution. Thank you.
So, you want me to go through line by line? Or?
Yeah, because that's your opinion. It's not a fact. Please read it. Thank you.
Okay.
No need to respond. Thank you.
Yeah, that's a ridiculous
Thank
question.
You.
So,
are there any additional comments or questions from members of the committee? Appreciate it, sir. Thank you. I will now ask staff to begin to accept public comment. For those physically present in the committee meeting, you will be given 2 minutes prior to your comments. Please remember that you may also submit your comments in writing to be submitted into the public record. We ask all speakers to please provide your name and affiliation for the record.
First up is Donna Leteri. And then after Donna will be Jenny Hauser.
I'm not here with any group. I'm representing myself. Children do come to Planned Parenthood with their friends. I see it often as an advocate on the sidewalk trying to offer them opportunities and counseling. I had a loving relationship with my parents. I was 23 and found out unexpectedly that I was pregnant. I was ashamed. I was embarrassed. I didn't want to tell them. I was somehow going to hide this for the rest of my life. But when I did tell them, they supported me, and I was thankful. I can imagine how a child would be so overrun with emotions and confusion. Steering a child to an abortion is predatorial. When I told my parents once the shock ran off, they did support me. You're Christian, you sing gospel songs, so do I. My God was my faith. My God was my rock. My God I trusted in for this issue. And boy, did he deliver. As a parent, I would want to be concerned about the potential life-threatening, long-term consequences of my child. This includes suicide ideology, depression, pregnancy, mortality, breast cancer, just to name a few. I will be there helping my child deal with these complications if I was notified. Planned Parenthood specifically avoids the parental notification of minors on their website. You can check that out. And they cover up predators. They cover up rapists. We're down at the clinic every weekend. We're in Seaford. We're in Dover. We see them bringing in kids. They're not associated with them. It's not their child because we've talked to those guys who drive those vans. 4 of my nieces and nephews were adopted. There's nothing haunting about that. 2 of my friends gave up their children for adoption. They're not haunted. They're glad that they gave them life and opportunity. But I do have many friends who did kill their children, and they're still haunted by that. A lifelong haunting, literally sometimes.
Thank you. Thank you. Next is Jenny Hauser, and then after will be Nina Raphosel.
My name is Jenny Hauser. I'm here to speak in support of HB 46. Some years ago, my then teenage daughter went to the mall to get her ears pierced, but she couldn't get it done without parental permission. It stands against reason that in the same state, at the same age, my daughter could have gotten an abortion without parental permission. This for a procedure that carries much more physical risk than ear piercing, that comes with a heavy mental and emotional weight, and holds lifelong consequences, all of which are reasons for parents to be part of this decision. One major concern for bypassing parental consent is that it provides a pathway for predators and traffickers to keep abusing minors and holding them in fear while allowing Planned Parenthood to destroy evidence of their misdeeds. I remember seeing a car leaving Planned Parenthood in Seaford on an abortion day. As the car drove by, the passenger turned and looked my direction. She looked like a child, a young child. The driver looked like he was in his 20s. Was she being trafficked? No way to know. But under current law, she could have been. That was a possibility. If no adult is accountable for the well-being of a child, particularly parents, then who will protect them? Please vote yes to HB 46.
Nina Raphosel, and then Nandy Randolph.
Thank you, members of the Health and Human Development Committee. My name is Nina Rapacelli. I am the Public Affairs Manager for Planned Parenthood of Delaware. Planned Parenthood of Delaware is in strong opposition to HB 46. Young people deserve access to safe, confidential, and timely abortion care. HB 46's parental or guardian consent requirement creates a significant barrier to minors, discouraging them from seeking the care they need and putting their well-being at risk. Delaware law already requires medical providers to notify a parent, guardian, grandparent, or licensed mental health professional before providing abortion care to a minor. This bill imposes additional hurdles that could delay or block timely access to abortion care. This bill also creates a judicial bypass procedure. While judicial bypass is often presented as a straightforward alternative to parental involvement laws, this process is fraught with obstacles and can be time-consuming, invasive, traumatizing, and lead to greater delays in care. Delays in accessing abortion care increase health risk, including physical, mental, and emotional harm. Reproductive health care providers are especially trained to handle sensitive situations like abortion care. These laws interfere with the doctor-patient relationship and undermine the trust between healthcare providers and young patients. Again, national medical organizations like the American Academy of Pediatrics and the American Medical Association oppose these parental involvement laws because they increase harm and delay critical care. HB 46 does not protect young people. Instead of making it harder for young people to access necessary health care, we should focus on ensuring they have support, care, and the privacy they need to make decisions about their future. Planned Parenthood of Delaware urges the committee to oppose HB 46 and prioritize the well-being, safety, and autonomy of young people in Delaware. Thank you.
Nandy Randolph, and then Javon Rich.
Thank you, Mr. Chair and members of the committee. My name is Nandi Randolph, Policy Analyst for Delaware Family Policy Council, and we fully support HB 46. At its heart, this bill recognizes a truth that transcends politics. Children deserve protection, guidance, and the involvement of those who love them most, their parents or guardians. No major medical decision should be made for a minor, particularly one as serious and life-altering as abortion, without the knowledge and consent of a parent. This is a matter of both moral duty and common sense. HB 46 is a law that is compassionate and balanced. The American Medical Association, the concerns that they present are for minors that are emancipated and those that have reached a level of maturity. HB 46 speaks to this by standing for minors that are under age 16. It allows for judicial bypass in cases where abuse, neglect, or coercion make parental involvement inappropriate. It respects the complex realities some minors face while upholding the principle that families, not clinics or strangers, should guide and protect children whenever possible. As a society, we have a sacred responsibility to guard the vulnerable. We should not leave young girls to make decisions with lifelong consequences without the care and counsel of their families. Young boys were allowed to opt out of paternity in 2022 with the passage of HB 432, with the reasoning that they did not have the mental capacity to do so. Let's respect the mental capacity of young girls and protect them as well. HB 46 reflects both wisdom and compassion, ensuring that parental involvement is the rule, with safeguards in place for those who truly need them. I urge you to support this important measure. Thank you.
The last comment will be from Javon Rich.
Good afternoon, dear Chair Chukwuka and committee members. My name is Javon Rich, and I'm the Policy and Advocacy Director at the ACLU of Delaware, and we're urging you to say no to this bill today. This bill would further create dangerous barriers to essential abortion care for minors under 16. Current law already requires minors to notify a parent before receiving abortion care. This bill goes further, requiring consent from a parent, which is an increased barrier for minors to access timely, safe medical care. It makes it significantly harder, if not impossible. For minors in an abusive or unsupportive household, this bill creates an especially cruel dilemma: risk their safety by seeking permission or forego the care altogether. Many minors who can't safely obtain consent will be forced to travel outstate, which increases financial burden. For those without financial means to travel, the outcome is worse. Delayed care can lead to more complex procedures or render the care inaccessible altogether. Ultimately, the bill makes it more difficult for young people to exercise the healthcare rights that they have, which can have lasting physical, emotional, and socioeconomic consequences. While the bill offers a judicial bypass option, and the current law does as well, navigating the court system can be daunting and intimidating for anyone, including myself. Expecting someone under 16 to engage with the legal system during such a vulnerable time is unrealistic and further delays access to health care. So we urge you to consider these implications and say no to this bill today. Thank you.
Thank you. That is the end of in-person public comment.
I will now ask staff to begin collecting the remote public comment for this legislation.
If you wish to comment on House Substitute 1 for HB 46, please use the raise hand function in Zoom. Each member of the public will be addressed in the sequence in which their hand is raised. Up first for virtual public comment, Bessie McAkamy.
Can you hear me now?
Yes.
Thank you. As a nurse of 59 years and representing other nurses in Delaware of over 500 years of experience, we urge the committee to vote yes for parental consent for this invasive procedure of abortion needs parental consent. As a standard of medical practice, minors must have parental consent for even an aspirin. The state now is highly concerned about human trafficking and sexual predators. Thus, the recent exposure by the AG office of 3 educators who have abused minors. Research has demonstrated that an abortion is used by traffickers and abusers to cover up their criminal behaviors with minor girls. Planned Parenthood advises girls on how to bypass the parental notification bill. In a sense, this bill provides the same opportunities to overtly bypass parental involvement. Nothing's changed. However, should the minor need medical treatment from injury or STDs, the parents are responsible for those medical bills. The state is also concerned about mental health for our minors. Research has shown that a post-abortion risk factor includes these negative mental health behaviors, even suicide. I speak also from having lost a niece to human trafficking, sexual predators, and death by suicide. It is hypocrisy at its best to promote health on one hand and death on the other. Please vote yes to protect our girls.
Up next for virtual public comment, Rachel Krantz.
Hello, yes, my name is Rachel Krantz. I live in SD6. Can you hear me? The Zoom is telling me to look. Okay. So I just wanted to note that several people in the question section brought up concerns about how this would affect children and teens who have abusive parents, or even who, in the worst type of situation, are pregnant by a parent. And I heard the response to those questions being, parents love their kids, and I know that because I'm a parent and I love my kids. So I ask you all to please understand that not every family looks like yours. Not every family relationship looks exactly like the relationship you have with your kids. And please listen to people who have different experiences than you. There is already a Delaware law that provides the protections that are claimed to be the intent of this bill. So this bill's only purpose, it seems, is to complicate a process and introduce mandatory judicial input. Our court system is extremely taxed right now, and this requirement will absolutely delay the timeline within which someone could seek medical care. If the whole argument is based on the fact that all parents love their children, and we know that for 100% fact, then this bill is made in ignorance. I wish it was true that 100% of parents were loving and caring. I really, really do. But we can't make laws based on the reality that we wish was true. Thank you.
Up next for virtual public comment, Leonard D'Amico.
Hi there, thank you. My name is Len D'Amico. I live in Wilmington, and I'm not representing any agency or group or anything here. I'm just commenting after listening to this testimony all morning. I just have 2 quick points. I echo the question of Representative Russellman and others. I would like to know what problem this bill actually seeks to solve, because the bill sponsor had no relevant statistics to share, and without evidence alluded to dozens and dozens, quote, of constituents who have called his office asking for this bill. Where are they? Why didn't they even testify today? He just brought in someone from out of state who didn't necessarily have any expertise in this area, which I found curious. And a second comment is that the bill sponsor continued to point out that if the parent doesn't give the consent sought by their pregnant child, they can simply seek a judicial bypass if they are experiencing abuse. But what didn't come up is, what if they're not experiencing abuse? What happens then? What didn't come out is that this basically ends up being a forced birth bill. And for that reason, and the reasons others have alluded to, I urge everyone to vote no on this bill. Thank you very much for your time.
There are no other hands raised, so that concludes virtual public comment for House Substitute 1 for House Bill 46.
Thank you. What is the pleasure of the committee? Motion to release by Representative Jones-Giltner and second by Representative Postles. We will now go to a roll call. Representative Chakwocha, no. Representative Burns,
No.
Representative Heffernan, no. Representative Johnson, no. Representative Ross Levin,
No.
Representative K. Smith, Representative Snyder Hall, Representative Jones-Giltner, yes. Representative Hensley, absent. Representative Filowski, yes. Representative Postles,
Yes.
Representative Shoup, yes. Representative Mike Smith. Yes. Having failed to receive the required number of votes, the motion fails. Chair members, please remember to come sign the bill backers before you leave the room. I will now ask for a motion to adjourn. Motion by Representative Johnson and second by Representative Burns. Thank you. The meeting is now concluded.
Wow. Well, what a hearing.
Well.
I have a whole book of notes here.
Oh, I have so much just to talk about a little bit here and there. It's just like, I mean, I wish I could say I'm surprised, but I'm not. But it's heartbreaking anyway.
Yes, it really is. I think and which we anticipated, but the main takeaway from this hearing is the attitude of the so-called experts toward parents. So they are more interested in protecting quote unquote children from parents that they feel are abusive than they are in protecting children from other individuals that are actually abusive.
Mm-hmm.
Now, don't get me wrong. Obviously, there are situations where there is abuse in a family. But as Representative Shoup said, that is already addressed in the bill. That's already addressed in Delaware Code. It doesn't make sense to assume the worst of all parents because of the few parents that are actually abusive. And that's what a lot of these comments are doing, is they're assuming that the general state of things is that parents don't have a good relationship with their children, so we should not require parental consent at all because of the few parents that are actually abusive. So it's just interesting to see that bias against parents and against the role that parents play in the life of their minors.
I think it's, obviously for a lot of our elected officials, it's become very emotional. And it's just this idea, you have to separate your personal emotion and just see the fact. You can't just put those lens on and not really see the intent, the real intent of this bill. We obviously heard from Representative Kendra Johnson, and how she did not grow up in a safe home and, got very emotional. But we're not talking, there is an issue that the notification clearly is not working, right? Because either the kids can put the address, whatever they want, so they can send an address to a friend's house.
Right.
And the only person needs to do is to sign it and say, I received it, and that's where it ends. But this idea of not, giving the rights to the parents who have to, if any complications happens, this is what the parents will have to cover, the
Right.
medical bills. They have to. And just not being able to be a support for the kids. And obviously, it comes with a lot of shame. Kids might be embarrassed of, what has happened, and obviously I mean, we all grew up and tried to hide stuff from our parents. I mean, I have done it. But again, that's not the intent of, I think there's a misconception of the bill. And also when Rose Levin, which we met with her yesterday, but when she said we need to trust women, I mean, we're talking about children.
Right. Yes.
I'm talking about a 12-year-old, 13-year-old, 14-year-old. We all know these ages, and they're making these major life-changing decisions, and they need guidance from their parents. I mean, it's just, man, it's tough.
Absolutely. And the scary thing about that is it sounds like they're, particularly with that legislator's comment, they're saying that 12, 13, 14-year-olds can consent to this major life-changing decision. So what implications, we already see inklings of the idea of lowering the age of consent in general.
Yeah.
And so you see how this is laying the foundation for that, for lowering the age of consent going forward. And so you can see those connections. You see that foundation being laid.
Yeah, absolutely. But there are reasons, like, it just, common sense sometimes, but like, what isn't that a kid who's 14 years old can buy alcohol, can get a tattoo, can, all this stuff they're not allowed to do. But where we'll say those seems to be superficial. They're life threatened, because if you consume, too much alcohol, it can hurt you. Your life can be in the line. But we're talking about physical procedure going into your body. It's like going into,
Absolutely.
It's
and then
crazy.
something Nandi brought out too in her testimony was last year or a couple of years ago, there was a bill passed that said that young boys who are minors they don't have to take responsibility for children that they produce.
Yeah.
And the reasoning for that was because those young boys are minors. And so the argument was, well, they're too young to consent to being a father. So if that's the case in that situation, then why are these minors able to consent to this life-altering decision? So, like you said, it's not consistent. It's contradictory.
Now, something that I was, looking at the committee. It's interesting that 4 or the new 5 elected officials that came in, the new elected officials, are 4 of them are in this committee.
That's very interesting.
Yeah. So you have Representative Frank Burns is there, Claire Snyder Hall is there, Representative Kamala Smith and Rose Levin are there, which are new elected officials just starting this year.
Interesting. That is very interesting. It's a high concentration of novice legislators.
But Representative Ortega is not. Interesting, right?
That is very interesting.
Just a little dynamic how things play out at times.
One other thing that I wanted to point out was another thing that was exposed in this hearing was the importance of having a worldview that's grounded in fact instead of emotion.
Yes.
Because you hear a lot of comments about how the children would feel in this situation. There was an example that was brought up of a young lady, or a person who at the time that she was a young lady was told to put her child up for adoption, and how she had the emotional effects of that going into adulthood. The implication of that is, well, it would have been better for her to be able to kill her child instead, right?
Yeah.
Because her feelings were geared more toward killing her child than saving her child's life. Now, any decision that's made, adoption, parenting, and even abortion, there are going to be strong emotional implications to those decisions. But that's not how we make our decisions.
Yeah.
We don't make it based on how we feel. We make it based on our conviction. We make it based on biblical worldview. We make it based on truth. And if we understand and have that biblical worldview, I think that's what the Bible talks about when it talks about peace that passes all understanding. Like, we're able to have and feel the emotion of peace regardless of the difficulties of our circumstances, if we know that we're walking in God's will. And so I think that was just an interesting point that was brought out in the committee. Obviously, a lot of our legislators don't have a biblical worldview.
Yeah.
So their standard is, well, how does this make this person feel? And we're seeing where that leads.
And also, like, the point that it was rose quite a few times, which I feel like Representative Shoup, and I want to say thank you to Representative Shoup for bringing this bill forward. But this idea of like, oh, they're not gonna have access to emergency needs, and I feel like he should have recorded his his answer, just play it again, because I feel like he kept coming up. Oh, it's gonna delayed this emergency access to medical emergencies, and he's like, we're not changing anything when it comes to that. And I think they're just trying to come after him with that sense, but obviously it did not stand because, they're not changing when it comes to Delaware law in that sense. When somebody needs an emergency, it's not going to be like, hey, call the parent, ask if they can do an emergency. But we know that abortion is not an emergency. I mean, sometimes could be in very specific that can be considered. I don't think abortion is it's as an emergency in any sense or form. But we do have somebody calling in, and if you want to introduce our Danielle, will be great.
All right. Well, Danielle, is she the one that's calling in? She is working for Americans United for Life, and she's the one that testified. She was Representative Shoup's expert witness. So it's great that she's able to call in and maybe share a little bit about what happened. Hello, Danielle. Thank you so much for joining us.
Absolutely. Thank you guys for having me.
And thank you again for testifying. I know you received a lot of difficult questions today, but I thought that you handled it really well. I know the majority in the committee were not in favor of this bill, but I just want to get a little bit of your thoughts, how you thought it went. What was your thoughts about the experience overall, particularly with you testifying?
Yeah, well, thank you, and thank you to everyone who provided testimony to in support of the bill. And of course, for your advocacy as well. You guys are pivotal in your state and in seeing, pro-life laws pass. So if I'm able to assist in any way, I'm happy to do so. So, I think that the hearing went probably as expected, and unfortunately, but I think these bills are such great messaging opportunities, even if they don't get passed, because you have the opportunity to hopefully raise some good awareness, even if it's just to the public that's there, as to the benefits of having a parental consent law and, the need to protect pregnant minors and ensure that the parents of these minors their parental rights are being, honored in the medical decisions that their minors make, so their minor children make. So I think that, I hope that at least my testimony was able to come across well in terms of providing some good points. I think that a lot of the questions that I received and that Representative Shoup received were what we expected as well. I think, again, the major concern that people had, and which in my own opinion were unfounded, but the major concern, of course, is that this bill is going to create some kind of barriers or to access, or put children in a bad position if their parents are, of course, abusive or neglectful. And as Representative Shoup said, and I said in my testimony and reiterated too, that thankfully the bill provides for procedures and methods that a minor can obtain an abortion if they are in a circumstance of abuse or neglect, or if they're experiencing a medical emergency. So I think a lot of what was said was, not necessarily accurate as to how the bill would actually be in effect. And the problem is, as Representative Shoup said, that the problem with the parental notification law as it stands is that, number one, it doesn't ensure that parents are the ones that are actually receiving notification about their child's wish to have an abortion. But also, two, it doesn't direct, even if it's just notification, that's not directly involving that parent in that informed consent process. And as Nandi testified in her own testimony too, the American Medical Association actually, even though we heard lots of statements about their position, their major concern is really for unemancipated minors. So they state in their position on the confidentiality agreements with, or their confidentiality position when it comes to children who are engaging in, sexual behaviors and things like that. Their concern is when there's parental consent requirements for minors who are emancipated. So therefore, no longer under the legal guidance, I guess, and of their parents. And so now, and they state very clearly that if it's an adolescent patient, that they would support parental consent, and the parents being involved if it's in the best interest of the child. So even the AMA's position is actually still falls, HB 46 still falls in line with the AMA's position. So I think we've heard a lot of different points in opposition that are easily dispelled, to be honest. But again, I think Representative Chu did a great job responding to those questions, and and I think that everybody that spoke to and supported the bill did a phenomenal job. And you don't have to be a medical expert to speak on a bill like this, right? As a Delaware citizen and not just an American, we have the ability to voice our opinions in terms of what we want to see in our states, and how we want our children and the children of others to be protected. And that, as a parent too, parents have rights, and they have constitutionally protected rights to the upbringing of their children. And so that's really also the heart of these parental consent bills, is that they are in line with, again, the rights parents have to make decisions with and for their children. And that's standard, and that's what I was saying, it's standard practice and best practice in every other area of the medical field, is to have your parents involved in that process when a minor is making a major medical decision. And so it's just abortion for whatever reason that they try to remove parents, but in any other circumstance, parents are involved. So I think again, the end result was disappointing, of course, but I think it was a great opportunity to educate the public and hopefully some members as to the needs, as to the lack of the current laws, or the gaps in the current law, and also the need to hopefully protect minors with some future safeguards. So I think there's still some good, of course, that came from, of course, the hearing, even though it may not have been the result that we wanted.
Yeah, absolutely. Yes. We always say every bill, every committee hearing is an invitation to a conversation, and it forces us to talk about the issue, and it forces the public to understand all of the nuances for all of these issues that would otherwise be swept under the rug. So I think that came out powerfully in this hearing. Again, I want to say thank you so much for coming, for testifying in Delaware. John, I don't know if you had any questions or comments?
Just quick. I mean, again, Danielle, thank you so much for testifying. Even thank you so much for calling in and just give us a little bit more of the insight of how you felt about testifying. I mean, we see these elected officials again and again trying to discredit the witnesses that are presented. One of them obviously was Representative Rose Levin, when he said, "Where is your expertise when it comes to the medical field?" But we're not talking about a medical issue. It's just a right that it has to be reflected in the law. And the rights that the parents have. So how, I would say, did that question, kind of like took you by surprise as they trying to, I would even dare to say, to discredit you, or that's a question that you were kind of expected that was going to be on your way?
Yeah, it didn't surprise me because you're absolutely right. I think that's a question people often throw out. And of course, I wasn't speaking for the perspective of a medical provider. I was speaking for the perspective of an attorney.
Yeah.
And my point that I was trying to convey, though, is that, we work with medical providers often within our organization. And so if I'm making any kind of medical statement or, any kind of study I'm stating, these are studies or statistics that I'm relaying that are from medical experts and from medical providers and other medical associations. And so, we're not just talking lip service, right? The things that I'm saying have weight to them, of course, even if I myself am not a medical provider. But yeah, I think it's just used to discredit people that they don't like their opinions of. But as you said, at the end of the day, what this bill is really dealing with is not necessarily, like you said, the medical field. I mean, it's involved with that, yes, but at the end of it, we're just ensuring that we're not saying what should or shouldn't happen in an abortion itself, right? We're not saying the type of care necessarily that abortion provider needs to be providing to that adolescent girl. We're just saying if she's seeking an abortion, the parent should be involved because they have her best interest most of the time in mind. And that's the presumption we should come from. We shouldn't come from the presumption that there's going to be always there's this conflict between parents and children, meaning that the minor is always going to be someone that wants the abortion and the parent's always going to want someone that does not want the abortion, or the presumption that abortion is always the right option for a minor. So those are kind of the presuppositions that were underlying a lot of the questions that I was asked, and they're not necessarily true or accurate. So, but yeah, the question didn't throw me off. I hope maybe I didn't answer as best as I would have liked to, but it's something that I hear quite often. But like I said, the reality is, even if this bill did touch more directly on abortion, you don't have to have a medical background to voice an opinion and be accurate and educated and have the right opinion. And you have every right to share your voice, regardless of whether you're a medical provider, because this touches everybody.
And just another comment, maybe if you can say in this, like, obviously you went through the bill itself, and the big concern that they kept going at is this idea, this is gonna delay emergency care for for is that true?
No, I don't see how the bill would result in any unreasonable delay for a minor, especially if they're in a medical emergency, because the bill maintains the state's current medical emergency exception where, if a minor truly is in an emergency situation where the provider believes that an abortion would be the best course of action, then they're able to have that even without parental consent. So, and again, even under the parental notification law, it had the same process for the judicial bypass procedure, the medical exceptions, et cetera. So this bill isn't adding any additional requirements in that way, other than ensuring parental consent that would cause any kind of unreasonable delay. And also, again, I would argue too that there's an assumption that if the process is delayed, that's going to be harmful to a minor, and that's not true either. There might need to be delay, right? If even if abortion is the end result, there could be delay because you want to ensure that the parents are involved, so that when the minor goes for an abortion, that the doctor or the parent is able to give the doctor all the relevant medical information that the doctor may need. Of course, we hope that that's not the case, but even if it is, we want to make sure that that minor still is able to have someone that's there that can advocate for them well, that might know, again, things about their medical history that they may not even be aware of, especially if they have a certain blood type that might be dangerous if the baby has a different blood type. There's lots of different, or an ectopic pregnancy, things like that can be very dangerous. And so it's just helpful to have a parent there and involved in that process to ensure that the appropriate steps are taken. So,
yeah, absolutely. Well, thank you again, Danielle. I know these hearings aren't always easy, but again, I really appreciate the level of information and knowledge that you bring to the table and that you brought to the committee hearing, the education that you provided, even just in talking with you right now. Just so much valuable information that I know will be helpful for me, and I'm hoping it's helpful for everyone that's listening as well. So thank you again, Danielle. I hope that the rest of your day goes well. I hope that you're able to rest after this morning. But thank you again for joining us.
Thank you so much. Thank you. And thank you all again for your advocacy. You all are on the front lines, and I know that you work extremely hard to advocate for life and for women. And so everyone here on this call I know does. So thank you so much for the opportunity of looping me in to the fight, because I know you guys are again on the front line. So if I can assist in any way, I'm happy to do so. But you guys are the main champions, and so I'm here to help you all. So thank you so much, and I hope you guys have a good rest of your day.
We appreciate that. Thanks so much, Danielle.
Thank you. Thank you. there he goes.
All right, that was great.
Yeah.
I loved hearing all of that.
This idea of like separating feelings, you know, it's just
Mhm.
with being able to see what the need is. And besides on a background, where we've been or, you know, what I experienced, it's just see the now. That's the other, yeah.
Right.
But
Absolutely. Yeah. And even I'll say this, you can interrupt me when, because I know we have another call
I
coming
got you.
in. But the idea that she was saying about being discredited because she didn't have any medical background. Remember
Yes.
in our previous hearing, we had someone who did have a medical background, but they said he was the wrong type of doctor. He
Yeah.
was in the wrong. And so it doesn't really matter. If the opinion that's presented is not fitting in with the narrative, then there's going to be a way for the legislators to find a way to discredit it. So it's not about the background. It is about, and as she said, she did talk with medical experts. Her organization does converse with medical experts.
Yep.
But the underlying issue here is the worldview.
Well,
And the
sorry to cut you off, but we do have,
there is Nandi.
it is Nandi Randolph with us. Thank you, Nandi, for calling in. How are you?
I'm doing as well as can be expected after that hearing.
Did you feel like the hearing was a little harder than expected in a sense?
I would say that I think it was just as difficult as we expected, and it really pointed out just how opposed the Democrat legislators are to parental involvement.
Yes.
They kept pointing out how this is supposedly some harm to the child, because despite what Representative Rossman said, these are not women, these are children. These are young girls that we're expecting to make this massive decision on their own without any sort of parental guidance. And it's very clear that that was the whole focus, to isolate them from their parents. And that gave some specific words to what we already know to be true.
Yeah, absolutely. Yeah, I thought it was interesting too. We were talking a little bit about this earlier. The assumption that the child's feelings on the matter are what dictate the decision that ought to be made. So they're talking about how individuals are scarred for life because they were not able to get the abortion. But of course, they ignore all of the evidence of individuals who are scarred for life because they got the abortion. But just this idea that the feelings are supposed to dictate reality and not the reality that obviously this is a living, breathing human being that we're talking about that's in the womb. And also the fact that minors aren't able to consent, like you said in your testimony, in other areas, legislatures recognize this, but not in this area. But one thing I had a question about all of the organizations that testified against ACLU, Planned Parenthood, and then there's obviously the American Medical Association, which Danielle talked to a little bit, and the ACP. Why do you think that those organizations are continually referred to for a lot of these same issues?
Well, it's very easy to see that these are organizations, especially ACLU and Planned Parenthood, they're lobbyists on the issue. And it is in their direct interest to remove any barriers from individuals obtaining an abortion. It is directly within their best interest to make sure that they can have the highest numbers as possible. So if parents are added to the equation and they have meaningful discussions with their children that help them to make a decision that is better for both them and the new life that's involved, that directly hits Planned Parenthood in the pocket. So of course they're going to say, no, we don't want this. That's absolutely understandable. And then the American Medical Association that was mentioned, it was mentioned a couple different times. One time the quote was actually to an opinion by an individual within the AMA and not the AMA as a whole. But if you look at the policy as a whole that they have, they are not opposed to parental consent, especially for minors that are quote unquote, not mature or not emancipated.
So we're producing HB 46, which is a bill specifically for minors under the age of 16 that doesn't even fit within what they are concerned about. They're not concerned about those young minors. They're essentially talking about the individual that's most likely 16 to 17 or someone who is emancipated, meaning that they are legally accepted to make all decisions without parental guidance. This bill doesn't even fit within that. So it was honestly a misguided representation of even what the AMA stands for themselves.
And also, like, obviously, at some point, got very emotional, with Representative Kendra Johnson, and this idea trying to install. I don't know if I picked it, but this trying to install that all these kids who need to or want to have the right or have that privacy come from a broken family. This idea, they come from a horrible background, that, their parents will be even worse to them, which is not, I mean, what would be the percentage? Probably very low. But there's a lot of, loving parents who care about the kids and that who want to be a support to the kids, and they don't have the right to do so.
Right. And honestly, even in some of the most mundane decisions, sometimes we see children, they don't wind up involving their parents and because they're embarrassed by something, because it feels awkward. I mean, there are wonderful, loving and supporting parents who don't necessarily know who their child's favorite author is or their favorite story or their crush, for instance, because as children are growing up, these kind of conversations can just be, they hide them for different reasons. Sometimes it's because they feel awkward. Sometimes it is because they just feel like their parents are just parents, right? And that does not negate the fact that the parent is legally and ethically responsible for the child, and the law sees them as the person that is best positioned to provide informed consent in every other capacity, right? As was mentioned by one of the testimonies, her young daughter was not even able to get her ears pierced without consent, yet could have this particular procedure if she chose to do so. And that's just, it's a complete duality that we're clearly not recognizing.
Well, Nandi, as always, we're so grateful for you, for all the work that you do at Legislative Hall, and helping our elected officials with witnesses at times, help them with information, or even just the intent of so many bills that are happening. You are able to dissect and everything that they really intend. But even in bills like this one, I know how much you have worked with Representative Shoup to bring this forward. It's so important, the rights of a parents just to come along. But thank you for all the work you do.
Thank you for that, John. I appreciate it. And though HB 46 did not pass today, it still remains that the parents are the best positioned to help their children through decisions that will stay with them for the rest of their lives. And this just happens to be one of them. And it seems it's the singular area that the government does not want parents to be a part of. And that's robbing children of that wonderful relationship with their parents and protection.
Absolutely. Absolutely. Well, thank you again, Nandi. I know it's always a long day when there's a important bill on the docket. So thank you so much for all the work you do behind the scenes. And thank you for all the coordination. And please pass our thanks along to Representative Shoup as well for leading the charge, and all the legislators that gave great comment today.
Thank you.
Well, have a great day, Nandi.
You too. You all have a great one.
All right, bye.
Bye.
Again, amazing work of our very own Nandi Randolph. But I think if I can, as we wrap up today, and I will say it's so, difficult to go through these hearings, and I'll do it all the time. I'm a Legislative Hall. And, what is it that, why is it that we can't get all this, I will say, life-giving rights even to parents. And I do want to give a word of encouragement, if that's okay with you, India, before we leave.
Absolutely. Yep.
So we hear, or we can read in the Gospel of John 14, in verse 27. This is what it says. And I shared this with some of our elected officials yesterday, especially with those that we will consider allies and people who are standing for biblical truth. But this is what it says. And this is Jesus' word. It says, "Peace I live with you, my peace I give to you. Not as the world gives do I give to you. Let not your hearts be troubled, neither let them be afraid." That's one. And then if we go to First Peter, which you just said a little bit about this, but First Peter chapter 5, verse 6 and 7 says this: "Humble yourselves, therefore, under the mighty hand, so that at the proper time he may exalt you, casting all your anxieties on him, because he cares for you." So now the difficult part of this verse, I will say, is verse 6. It says, humble yourself. And that's tough, because humble yourself means you have to submit yourself to God. In a bill like today, in a hearing like today, when you be like, God, what are you allowed to, this to happen? But it says at the same, and I said, at the end of the day, we've been faithful to the Lord with what he has called us to. Now, there are things that are out of our control. They are in his control, but it's out of our control. But we need to cast our anxieties, our worries on him. Because at the proper time, God will give justice, and we will be able to see truth. But also, in this idea that because he cares for us, and God cares for our state. I mean, he does. God cares for our elected officials. He does. And always we can see these elected officials, those that are not, are not able to see truth. A lot of them are not just able to see common sense or truth. It's really hard for us to understand why. But like this idea of like a bill like today, it just makes sense to have a bill like today. Yet they're not able to see it. But we need to humble ourselves and submit to the Lord. Why? Because he's the chief shepherd. He's in control of all things. And in his due time, this is what it says: at the proper time, he may exalt you, and he may exalt truth at his time. So I will say, for those that are listening, don't be discouraged, but continue to fight. Fight the good fight. We need to continue to bring forward truth, what God's word says, and that truth will prevail.
Absolutely, John. That was really encouraging. Thanks for closing us out on that word. We have our call to action to move forward. And part of that fighting is discipling in our own communities, discipling in churches. I mean, I think if anything, this hearing shows the need to strengthen the relationship between parents and children and learn about what the Bible says about that and what a healthy parent-child relationship looks like. So that's a call to action for our churches and for those of us who are discipling. But thank you again for all of you guys for tuning in. If you want more updates for the bills that are coming forward, for the bills that are currently in circulation as they move through the process, go to delawarefamilies.org/updates if you're not already getting those alerts. Again, that's delawarefamilies.org/updates. And we will see you again for the next legislative hearing.
That sounds good. Bye, everybody.